The first lesson I would say is don't just shake on it, put it in writing. In the case of artists and dealers, for example, the idea of executing a written contract seems crassly commercial for such a unique and near mythic personal relationship. Since the art world's culture is based on trust, where deals are often sealed with a handshake, there's a natural aversion to a formal written document that's outlining the obligations of the artist and the dealer. However, this notion is as romantic as it is unrealistic, because the artist-dealer relationship is essentially a business arrangement. And without the benefits of a written document, each side lacks a full understanding of the other's needs, and even a minor problem can escalate to a major dispute. It is far easier to address confusion at an early stage when the parties at least are trying to make the relationship successful rather than later after a problem has arisen. Also, the contractual process can be an important tool to clarify the parties' expectations of the relationship. Usually, a simple letter of understanding will suffice because it obligates the parties to spell out important terms, averting later confusion and misinterpretation. In addition to protecting the artist and dealer, a written agreement protects third parties. If, for example, an artist consigns a work to a gallery, which later declares bankruptcy, a written agreement acknowledging the intentions of the parties can save time and money by proving that the works were consigned to the gallery by the artist and are not subject to the gallery's creditors. To put it simply, oral contracts work well until they don't. The possibility of misunderstanding over responsibilities and expectations become fuel for discord and may cause the relationship to unravel. If a dispute can be resolved amicably through discussion and negotiation of the agreement becomes critical. Another consideration is the statute of frauds, which requires that certain agreements must be in writing in order to be enforceable. Contracts for the sale of goods over $500, for example, must be in writing to be enforceable, and that is probably the case with many artworks. Agreements that contain a promise that cannot be fully performed within a year of the agreement also must be in writing, or it is not enforceable. To prove the existence of an oral contract can be formidable when a dispute arises. And moreover, if an agreement is not in writing, a contract is implied rather than express, and its terms will be provided by the legal system rather than the parties themselves. As an illustrious scholar in art law, Professor Merriman from Stanford observed, if you want a bad contract instead of a good one, the law will supply it for you. If you want a good one, you must make it yourselves.